special leave to appeal under its discretion from any judgment, decree, sentence or order in any case or matter made by any court or tribunal subordinate to it in a case. That it is hereby humbly submitted that there has been a serious miscarriage of justice by the acquittal of the matter by the Honorable High Court, which includes the High Court judgment contradicts the established legal principles regarding the burden of proof in case of insanity, legal insanity. The judgment disregards significant evidence that establishes the accused's mental state and it undermines the integrity of the decision. Inadequate consideration of medical evidence and also the respondent failed to prove the legal insanity. A dying declaration serves as the basis for conviction and both standards must be met for its credibility but overlooked by the High Court. The principles established in the case of K.K. Verma versus Union of India highlight the court's role in correcting errors that may lead to a miscarriage of justice, particularly when there is a misreading of evidence. Your Lordship, page 1 of arguments advanced.
It's a one level overload. In your number 5.
It is overruled. The council begs ignorance, Your Lordship. The council begs ignorance. Here in this instant case, the Honorable High Court has denied not only justice to the petitioners, it has even failed to even consider the crucial points of law and material facts involved essential to decide the case upon merits. Hence, there is an overwhelming error on the part of the High Court leading to severe injustice and loss to the appellants. Thus, the Council for Appellants would like to invoke the jurisdiction of this Honorable Court and remedy the above injustice. That this instant petition satisfies all the grounds that are required for an appeal under Article 136. It is therefore humbly submitted that if special leave is granted and the same is restricted to a particular question. Moreover, even if it is assumed that this instant petition is not maintainable, this Honorable Court can still hear the matter. It is humbly submitted that the will of the discretion of this Honorable Court may extend to a situation where, although the appeals are found not to be maintainable, yet the Supreme Court may decide the merit of the appeals. Hence, it is humbly submitted to this Honorable Court that this situation requires immediate attention of intervention by this Honorable Apex Court to avoid any further injustice to the petitioners. If your Lordship is satisfied with issue number 1, the Council seeks permission to proceed with issue number 2. Whether sufficient ground of...
You talked about like miscarriage of justice, right?
Yes.
What miscarriage of justice exactly involves here? And you also talked about the discretionary of the court, right? So this court believes that we are not proceeding with your petition. It's up to our discretion, right? But please convince us why should we interfere in this petition?
Your Lordship, in the present case, the High Court has misread the evidence by over-relying on the defence's psychiatric testimony without properly applying the legal test for insanity under Section 22 of Bharatiya Nyaya Sanhita. It ignored the pre-prosecution evidences such as the dying declaration made in a very mental state, sound state at the time of the act. This led to an erroneous acquittal, warning Supreme Court's intervention. So it requires the Supreme Court to hear us and give us justice. The McNaughton rule, which came from a very famous English case. The case name is R versus Daniel McNaughton, 1843, has laid down 4 rules to check whether a person can be capable of legal insanity or not, and the 4 principles that are laid down by the McNaughton are as follows. Every person is supposed to be sane and to possess sufficient degree of reason to be responsible for his acts until the contrary is proved. In order to establish the defense of insanity, it must be clearly shown that at the time of committing the offense, the person was so insane as to not know the nature and quality of the act he was doing, or if he did know it, he did not know that what he was doing was contrary to the law or wrong. The test of the wrongfulness of the act lies in the capacity of the person to distinguish between right and wrong, not in the abstract or general, but in regard to the particular act committed by the person raising the defense of insanity. It is for the jury to decide whether the accused was insane or not at the time of committing the offense. The Calcutta High Court in Ashiruddin Ahmed versus the King has laid down 3 tests, and they are that the accused was unaware of the nature of the act, accused was not aware that this act was contrary to the law, and accused was not aware that this act was wrong. It is humbly submitted before this honorable court that the respondent cannot be exonerated from the liability of murder because their does not exist sufficient grounds of legal insanity to exonerate the accused from liability of murder. So, according to national
Counsel, EW1, the doctor, he's already confirmed his insanity here.
Your Lordship, in your Ladyship,
You want to go against the doctor's confirmation?
no, your Ladyship, in McNaughton rule, they have clearly seen that a medical insanity is not acceptable or justifiable in the court of law. Only a person has to be legally insane to prove his insanity, to take the plea of insanity. But we have seen that he has not fulfilled the tests that are laid down in the McNaughton rule. So maybe he was medically insane, but he was not legally insane, your Ladyship.
But in any method, as counsel, how does it differ between medical insanity and legal insanity here? He was insane.
Your Ladyship, medical insanity just refers to a medical diagnosis of mental illness, while legal insanity, for a person to be legally insane, he should be of death severe, he should suffer death severe mental disorder to make his for that he does not know these actions are contrary to the law or wrong. But in this case, he knew that his actions were contrary to the law. That is why he has done certain acts which has been stated by our witness Gabriel. That Gabriel saw Robert hiding the eggs in the garden, which shows that he was mentally fit enough to do all the acts he was doing. According to National Institute of Mental Health and Neuroscience, bipolar disorder is a mental illness that causes clear shifts in a person's mood, energy, activity level, and concentration. It also includes anxious distress, melancholy, and psychosis. In the instant matter, the respondent's bipolar mood disorder, according to a medical evidence, is a mental illness in Mental Health Act 2017, which says Section 2S of Mental Health Act 2017 says mental illness means a substantial disorder of thinking, mood, perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life. Mental conditions associated with the abuse of alcohol and drugs, but does not include mental retardation, which is a condition of arrested or incomplete development of mind of a person, specially characterized by subnormality of intelligence. It is humbly submitted before this honorable court that the judgment of the High Court of Yaza acquitted the accused from the charge of the murder on the basis of legal and medical insanity on dated 25th January 2025 is clearly a miscarriage of justice under Section 22 of Bharatiya Nyaya Sanhita, which was earlier Section 84 of Indian Penal Code, and it states that nothing is an offence which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Your Lordship, in Intra versus Gwala, a decision was relied upon by the learned assistant government leader. It was held that a person is not entitled to exemption from criminal liability cases in which it is only shown that he is subject to insane impulse while his cognitive facilities remain, so far as can be judged from his actions and words unimpaired. It was held that there were the session judge drew an inferencement of derangement of brain from the very nature of the act done by the accused. Such a test was inadequate, and one must look outside the act itself for the evidence as to how the accused knew about it. In the case of Emperor versus Gwala, absence of any motive, absence of secrecy, want of pre-arrangement, and want of accomplices were not found sufficient to constitute a reference under Section 84. It was held that these circumstances by themselves were insufficient to support the inference that the accused suffered from unsoundness of mind referred to in Section 84. In the case of State of Maharashtra versus India Alliance Raman, the court clearly laid down the distinction between medical and legal insanity. The court held that the effect of medical insanity on the cognitive abilities of a person varies with the nature of the medical condition, and it might be possible from that the unsoundness of mind due to mental illness might still not make a person eligible for insanity defense as per Section 84 of the IPC and now Section 22 of BNS. This means that even under the influence of a mental illness at the time of committing a criminal offense, if a person has the capacity to know the nature of the act or to know the wrongfulness or illegality of his act, he shall not be given exemption from his criminal liabilities. Your Lordship, in the case of Surendra Mishra versus State of Jharkhand, The court was dealing with a case where the accused was diagnosed for an offence under Section 84, and while denying the protection of Section 84 of the IPC to the accused, the court held as under. An accused who seeks exoneration from liability of an act under Section 84 has to prove legal insanity and not just medical insanity. Expression unsoundness of mind has not been defined in the Indian Penal Code, and it has mainly been treated as equivalent to insanity. But the term insanity carries different meaning in different contexts and describes various degrees of mental disorder. Every person who is suffering from mental disease is not ipso facto exempted from criminal liability. The mere fact that the accused is coincident, irascible, and his brain is not quite alright, or that the physical and mental ailments from which he suffered had rendered his intellect weak and affected his emotions, or indulges in certain unusual acts or fits of insanity at short intervals, or that he was subject to fits and there was no abnormal behavior, or the behavior is square and not sufficient to attract the application of Section 84 of Indian Penal Code. Your Lordship, the apex court in Sherali Wali Mohammed versus the state of Maharashtra has clearly held that it would be most dangerous to admit the defense of insanity upon the arguments derived merely from the character of crime. The mere fact that no motive was proved as to why the accused committed the crime of murder, not the fact that he made any attempt to run away, he made any attempt to run away from the spot, would not be indicative of his plea of insanity to look or lack of necessary mens rea for the commission of the crime. The Honorable Apex Court has further held in the matter of Prakash Naik Singh versus State of Goa that Section 84 of IPC, Section 4 of Indian Penal Code recognizes only an act which could not be termed as an offence, and it starts with the word "nothing is an offence." The said words are a clear indication of the intentment behind this laudable provision. Such an act shall emanate from an unsound mind. Therefore, the existence of an unsound mind is a sine qua non to the applicability of the provision. A mere unsound mind per se would not suffice, and it should be to the extent of not knowing the nature of the act. Such a person is incapable of knowing the nature of the said act. Similarly, he does not stand to reason as to whether an act committed is either wrong or contrary to law. Needless to state, the element of incapacity emerging from an unsound mind shall be present at the time of commission.